Hi there, welcome to Rent Prep for Landlords. I'm Andrew Schultz, Community Manager here at Rent Prep. I'm also a licensed real estate broker in the state of New York with over 14 years of experience in the rental property and property management industries. On today's episode, we're going to be talking about the White House blueprint for a tenant's Bill of Rights. We're going to take a look at the good and the bad, and we're also going to answer some questions on what's being proposed. It's going to be an interesting show, so stick around. I think the best way to go about reviewing this document is to spend most of our time actually taking a look at it, and I'll comment on the various sections as I'm running through it. It is important to note that I'm not an attorney, obviously, but I do own a property management company, so most of the perspectives that I'm going to be providing here are going to be from that perspective. You may agree or disagree with my takes, and that's totally understandable, but it's important to understand what is being proposed regardless, as it is going to have an impact on your business as a landlord. So to start things off, we're actually going to start here in our PDF editor. I've gone through and highlighted some sections. I'll read through a bunch of stuff here, but I'm not going to read through everything. If you do want to take a look at this document, it is available on the White House website. You can just go to the White House website and search Blueprint for a Renter's Bill of Rights, and it'll pop up right there in the search results. It's a pretty easy document to find. They are pushing this out pretty heavily. So we're going to go ahead and take a look at this. We're going to start right here in the intro. The Blueprint for a Renter's Bill of Rights is a statement of principles. It is not binding and does not itself constitute U.S. government policy. Basically, everything we're talking about here is theoretical. So it's important to mention that part up front as we start to get into things here. And I'm going to kind of skip into this next section here before we get to section 1. This is also part of the intro, but it just kind of lays out the 5 common sense principles that they're talking about here. Safe, quality access to affordable housing, clear and fair leases, education, enforcement, and enhancement of renters' rights, the right to organize, and eviction prevention, diversion, and relief. Some of this sounds a little bit better than other parts of it, but we're going to go ahead and jump into these different sections here, starting with the first principle, which is access to safe, quality, and accessible affordable housing. Renters should have access to housing that is safe, decent, and affordable, and should pay no more than 30% of household income on housing costs. Owners of rental housing and state and local government should ensure that homes for rent meet habitability standards and are free of health and safety hazards such as lead or mold. In addition, owners should provide services and amenities as advertised or included in the lease, such as utility costs and functional appliances, and ensure that the residential housing unit is well maintained, including common areas. The 30% is a good rule. I find that most tenants are the ones putting themselves in a position where they are in violation of the 30% rule. And I think that that's probably because most landlords don't screen properly, to be honest with you. We screen for 3 times the rent in net income for every applicant that we screen. And we find that many tenants don't necessarily hit that criteria, but they go ahead and apply anyway, which puts them in a position that if they get approved by a landlord that doesn't screen properly, they could be in a situation where they're spending way more than 30% of their monthly revenue on an apartment. And honestly, they really shouldn't be. This boils down to both landlords and tenants understanding what is affordable and what is not affordable for their budgets. Tenants need to understand that if you're looking to stay under 30% of your income, you need to look for apartments that meet that standard. And landlords need to understand that accepting a tenant that doesn't have the income required to basically rent an apartment and keep that apartment successfully rented, i.e. the rent being paid on time, that's not a tenant that you want to approve. Renters should face minimal barriers when applying for housing and receiving housing assistance, which includes minimally burdensome application and documentation requirements and fair and equal tenant screening. Minimally burdensome application is a bit too vague in my opinion. I think that asking people to prove basic facts about who they are, what they do, how much they make, where they've lived in the past, none of that should be off the table, in my opinion. All of that should be things that people can prove very easily and have documentation to prove very easily. And realistically speaking, it's the responsibility of the housing provider to know and understand who is living in their units, who they're renting to, and things of that nature, because ultimately it's the housing provider's responsibility to ensure that they're providing that safe housing. You want to have safe housing, you need to be able to screen your tenants, and part of that is tenants going through an application procedure. Scrolling down here a little bit, still in section 1, there's this section that talks about using the FTC, which is an independent agency that it wants to expand its use of its authority under the FTC Act to take action against acts and practices that unfairly prevent consumers from obtaining rental housing. This is absolutely government overreach, in my opinion. The FTC, in all reality, should have zero interest in regulating housing. We already have several agencies that are set up to regulate housing. We don't need another in the mix. Scrolling down a little bit to this section on Department of Defense housing, DoD will ensure that military members can receive housing assistance from their installation's military housing office, regardless of whether they live on or off base, to include assistance finding suitable, affordable housing, inspecting units prior to leasing, negotiating rents, reviewing leases, resolving landlord disputes, and addressing acceptable housing issues and potential housing discrimination complaints. I've known a lot of service members over the years. I know a lot of active and I know a lot of retired service members, and pretty much the one thing that they've universally told me is that base housing is awful. It wouldn't even pass a Section 8 inspection in a lot of instances, wouldn't come anywhere close to it. So I think that that's probably something that needs to be looked into a little bit deeper as well. My understanding is that in a lot of instances, there are private parties, private property management companies that are running base housing. And when you have a situation like that, oftentimes they're running it in the way that's most profitable for them as a property manager and not necessarily in a way that's most acceptable for our service members. Scrolling down a little bit, building from existing stakeholder agreement, the White House, Department of Agriculture, the Department of Treasury, and HUD will meet with a broad, diverse, and varying group of tenants and tenant advocates on a quarterly basis to hear their perspectives on dynamics in the rental markets and opportunities to strengthen tenant protections. My biggest problem with that statement is that there's literally no mention of having landlords at the table. You want to talk about having your stakeholders in place? Landlords are a major part of this, and not having landlords even brought up in that section really kind of threw a red flag for me. Scrolling down a little bit here into this section on USDA, USDA will pilot a program in 2023 that will institute a uniform and an independent inspection protocol across its housing portfolio, using trained inspectors and ensuring equitable treatment of tenants. And then just below that, Inspire aligns multiple HUD programs to a single set of inspection standards so that the same expectations of housing quality can be achieved across HUD programs. I am a big fan of this one. I'm a huge fan of a universal set of inspection standards for subsidized housing. And in all reality, we see this happen a lot with Section 8 agencies, where from agency to agency, and we have, I think, 4 or 5 different agencies here in Western New York that deal with Section 8 vouchers, it's very inconsistent what one agency will tag versus another agency. And realistically speaking, it's even worse on an inspector by inspector level, even inside the same agency, because some inspectors will tag things that other inspectors simply will not tag. And when you have situations like that, it's very difficult as a housing provider to know and understand what the requirements are going in so that you can pass these inspections on the first time. In my opinion, a universal set of inspection standards when it comes to affordable housing or leased housing, voucher housing, whatever you want to call it here, that is a good idea. That's something that I would actually get behind. We're going to go ahead and move on into Section 2 here. Go ahead and pop that up on the screen. Section 2, clear and fair leases. Renters should have a clear and fair lease that has defined rental terms, rights, and responsibilities. Leases should not include mandatory arbitration clauses, unauthorized terms, hidden or illegal fees, false representations, or other unfair or deceptive practices. I think that we can all agree that that's pretty straightforward. A lease should provide a transparent policy regarding deposits, with those deposits being appropriately sized and placed in an interest-bearing account for the duration of the lease. I don't have necessarily a huge problem with that. I think that the biggest issue is going to be that we're trying to shrink security deposits when we need to be expanding them. The lease should also provide for reasonable advance notice of actions related to the unit, including notice of entry for inspection by the housing provider and significant changes to the unit. Finally, the lease terms should be written in simple and clear language accessible to the renter, and the leasing process should ensure that tenants understand the terms of the lease through a plain language briefing. Realistically speaking, I think that there's a little bit of vagary in there, especially when you're talking about things like hidden or illegal fees. That needs to be a little bit more clearly defined. And this needs to work both ways, such that if a tenant causes a bunch of damage in a unit, there is a mechanism by which a landlord can go back against that tenant for those damages. And it doesn't even need to be damages. It could even be something as simple as non-compliance with a lease. So if you're going to do something like this, where we're spelling out what are allowable fees, what are not allowable fees. I hope we're not setting limits on those fees, which like we're starting to see here in New York with application fees and things of that nature. But realistically speaking, if you're going to start legislating what is and is not a legal fee, I think you need to define that a lot more clearly when you get to the actual legislation portion of this. Scrolling down a little bit, there's a mention here that research also suggests that consumers often do not read contracts. In the case of residential leases, some renters may not read their lease at all because they see it as a take it or leave it document. Others may not read it because they believe it is written in legal language that they will not understand. Few renters who read the lease and find concerning provisions mention their concerns to landlords or leasing agents or contest the lease. A lease is a legal contract. There's no other way to look at it. You need to read a legal contract before you sign it. If you have questions, you need to ask them before you sign it. There are so many resources out there right now, many of which are free or low cost, that will help people to understand legal documents, including leases, before they sign off on them, that there's really no excuse for this. If you're going to sign a legal document, you need to accept the responsibility that you are signing and are going to be bound by the terms of that agreement. Should the agreement be fair? Yes. Should the agreement be clear? Yes. But should you be responsible for it once you've signed off on it? Yes. No questions asked. Scrolling down a little bit here, they talk about security deposits. I just highlighted this, not necessarily because of the overarching portion of the paragraph, but specifically just this sentence. Such policies are important because security deposits are a standard part of most housing lease agreements, but are often a barrier for low-income tenants to secure housing. Understand that there are a lot of different people fighting against security deposits right now, in a lot of ways. Many people want to see caps on security deposits. For instance, New York State has now capped us at 1 month of rent, which basically caused harm to the very people it was meant to hurt, in the form of us no longer being able to offset risk with perhaps a tenant that may not be approvable, by offering them the ability to pay an additional security deposit and still get that apartment. What happened? The tenant screening criteria got tighter, not looser. So the legislation that was designed to help tenants in that instance hurt the very tenants that it was designed to help. I want to mention specifically that there are a couple of companies out there that offer security deposit alternatives. I'm not going to name names, but those companies are not your friend as a housing provider. It was recently posted in one of the landlording groups that I follow on Facebook that one of those groups is actively lobbying against landlords and is trying to get a cap or a reduction in the amount that they can charge for security deposits in some states, because that makes their product that much more appealing. So I would say to you, if you are planning on using a security deposit alternative program, maybe look for programs that aren't named after animals and programs that actually have the best interest of the landlord at heart. Scrolling down a little bit further here, I believe that puts us into section 3, which is the third principle, education, enforcement, and enhancement of tenant rights. And jumping into our third principle here, we're going to start with the first paragraph. Federal, state, and local governments should do all they can to ensure that renters know their existing legal rights and to protect renters from unlawful discrimination and exclusion that can take many different forms. Government bodies at all levels should ensure that the rights and protections provided under the Fair Housing Act and other federal laws and regulations, as well as state and local fair housing laws and regulations, are known and enforced. I think that makes sense. If you're going to have fair housing legislation, it should probably be enforced. Scrolling down here, source of income discrimination is the practice of not renting to a household or withholding property, services, facilities, or privileges based on the source of income of the individual, which can include a housing choice voucher, which is a Section 8 voucher, or other forms of housing subsidy, or non-wage income sources such as alimony or child support. Source of income discrimination can be used as a proxy for other forms of discrimination. Laws that ban discrimination based on source of income can both increase a household's ability to find housing with a housing choice voucher and broaden the neighborhoods they can access. Further efforts to partner with housing providers and reduce administrative burdens associated with accepting rental assistance serves as an important complement to such mandates. Source of income legislation is a good thing, whether you like it or not. But they're missing two key words here. Those two key words are lawful and provable. If I can't prove it, I can't use it. So someone that's working off the books for cash, that's neither a lawful nor a provable source of income. I can't count that. There's no way for me to be able to verify it. You're working off the books, which isn't legal, and you're receiving cash off the books, which isn't legal. That's not income that should be counted. So if we're going to do source of income laws, I agree that we should have source of income laws. We already have them here in New York. We've seen no real issue with our screening as a result of having the source of income laws. But if you're going to say source of income, you need to say lawful and provable source of income, not just source of income, because I don't want to accept somebody's written word. We're not doing no doc, low doc loans. This isn't 2007, 2008. We need to be able to prove the income is coming in from a lawful source if we're going to accept it. Scrolling down a little bit further here, we're going to start talking a little bit more about credit and background checks. The CFPB has said that it will identify guidance or rules that it can issue to ensure that background screening industry adheres to the law and coordinate law enforcement efforts with the FTC to hold tenant background check companies accountable for having reasonable procedures to ensure accurate information in the credit reporting system. This is very, very good. There was a property management software platform, I'm not going to mention the name of it, but it was sued for not verifying that they had accurate information in their credit and background checks before sending those credit and background checks off to the housing provider to make decisions. When you're working with flawed data, you're making flawed decisions. So I absolutely believe that there should be some checks and balances in here to make sure that the information that we're being provided as housing providers is actually accurate information. HUD, FHFA, FTC, and USDA have said that they will work with CFPB to release best practices on the use of tenant screening reports, including the importance of communicating clearly to tenants the use of tenant background checks in denying rental applications or increasing fees, and providing tenants the opportunity to address inaccurate information contained within background screening reports. Technically, we already have this. If you deny someone based on a credit or background check, you are supposed to send them an adverse action letter. I know that we do it out of our office. I think that most landlords that are running credit and background checks are pretty compliant on this, but it would not surprise me to find out that there is a subset of landlords that's not being compliant on this. As with any law, there are some people that are just never going to be compliant. My problem with this is that we need to clarify the laws that are on the books already. Give us proper guidance. For instance, when it comes to screening someone with a criminal background, we aren't the judge, we aren't the jury, we didn't hear the case, and we didn't see the evidence. Telling us to figure out if we're creating a disparate impact when screening someone that has a criminal history is a recipe for disaster. For that exact reason, you're not giving us all the information and you're telling us to make a decision based on information that may not be complete, which in turn leads to problems, which in turn can lead to lawsuits. If you want to be able to sue somebody, you have to be able to give them the correct information to operate from. And honestly, in my opinion, the more you limit tenant credit and background checks, the less accurate the information is that we're actually going to be operating from. We have the same issue with situations such as emotional support animals, where there are fake websites out there that will generate fake paperwork just to help a tenant get a pet approved that shouldn't be. There's no repercussions almost for something like that. It's very difficult to track down. It's very difficult to prove. And it's one of those situations where, again, the guidance is bad. So we're trying to make decisions based on faulty information. It's a bad situation to be in. Scrolling down a little bit further here, HUD will explore opportunities to address source of income discrimination through guidance. And again, if you're going to make guidance, you need to make sure that that guidance is crystal clear. I want to make mention of public housing authorities, specifically some of these Section 8 agencies. They need to be easier to work with if you want to increase landlord participation. What I mean by that is very simple. Many tenants on Section 8 vouchers come to us looking for apartments. They don't even know what their voucher value is. They don't know what their portion of it is going to be, which makes it impossible for a landlord to actually screen a Section 8 tenant correctly. If you're going to arm a Section 8 tenant with a voucher, you need to arm them with all of the information revolving around that voucher. How much is the voucher worth? How much is the Section 8 agency paying? How much is the tenant paying? I understand that there are variances depending on whether utilities or appliances or things of that nature are included. But again, this seems like there must be a formula somewhere. They're not just divining these numbers from nowhere. So you should be able to provide tenants with information that, okay, if you rent a 3-bedroom apartment and it includes the gas, we're going to give you this much more. And it includes the appliances, we're going to give you this much more. So that a landlord and a tenant can sit down and make a safe and competent decision when it comes to tenant screening, when it comes to some sort of a Section 8 or housing voucher or something of that nature. But only giving us half the information and telling us to make a decision only leads to negative outcomes. That puts us into our fourth section. Fourth principle, the right to organize. Renters should have the freedom to organize without obstruction or harassment from their housing provider or property manager, and should not risk losing their housing because of organizing. Moreover, tenant associations should be recognized by their housing providers or management companies. A renter should be able to identify the owner of their building and how to contact them to engage in important conversations about their property. Such engagement should be a feature of a healthy and productive tenant-landlord relationship. This is basically the intro to tenant unions. It's very, very straightforward. They say it right in the title of this section, the right to organize. That's a union. Tenant unions are what they're pushing for here. Scrolling down a little bit, that's pretty much the main thing that I wanted to draw out of section 4. But I do want to mention that there are way more tenants than there are landlords. Obviously, we already know that. The best way to protect your interests as a landlord are to keep your buildings clean, safe, well-maintained, and secure, and to stay active in the landlord groups in your area. Pay attention to pending legislation at a local, a state, and a federal level as to how it's going to have an impact on your business, and you need to make sure that you're participating in a way that shows politicians that this matters to you. You are a voter, you are a taxpayer, tenants are voters, tenants are taxpayers, everyone's voice needs to be heard. There are a lot more tenants than there are landlords. You need to make your voice louder. Participate in local, national, state landlord groups and understand what legislation is coming down the pipeline and how that legislation is going to affect you as a property owner. Moving into our fifth and final section. Fifth principle, eviction prevention, diversion, and relief. This is a very, very in-depth section. Obviously, it's probably the most in-depth section here because this is the section that most people probably jump to first. Renters should be able to access resources that help them avoid eviction, ensure the legal process during an eviction proceeding is fair, and avoid future housing instability. To prevent evictions, renters should have access to just or good cause eviction protections that require a justified cause to evict a tenant, and tenants need to receive adequate notice if their lease is not being renewed. This document does not specify what good cause eviction or just cause eviction would look like anywhere in the document. All of that is left completely vague, which in my opinion is completely unacceptable. New York State is pushing good cause eviction legislation right now, and it's egregious in so many ways. That's a topic for another video entirely, but this legislation strongly is encouraging legislators to strip housing providers of their ownership rights with just cause and good cause eviction protections. This is absolutely something that you need to keep a watch on, whether it be at a state or a federal level, because this will have a major impact on how you run your business. Moving on in this section, renters should be able to avoid an eviction filing through alternatives to the eviction system, such as eviction diversion and grievance procedures that prevent formal legal proceedings through negotiation, mediation, or arbitration. Resolutions from these processes could include a grace period for late rent, the ability to preserve tenancy through curing the lease violation by paying rent or correcting the violation, access to a standardized formal dispute resolution process prior to litigation, and opportunities to meaningfully participate in a pre-eviction diversion program. Listen, no housing provider chooses eviction as their first choice. By the time we get to a point where we're filing a court action, we've already tried to have conversations with tenants. We've already tried to negotiate things and come to a resolution. Court is the absolute last move that a landlord is going to make, not the first move. We don't want to go to court. It costs time, it costs money, and it's bad for everybody involved. Slowing the court process down by forcing us to go through some sort of a mediation prior to being able to file a court docket is not going to help any of the situation. If an eviction is filed, tenants should be given 30 days notice of an eviction action and the right to counsel during an eviction proceeding. I'm just going to stop right there. 30 days is way too long. In New York State, it used to be 3 days, and now we have a 5-day grace period followed by a 5 and 14-day notice that need to be issued. Slowing down the process of removing bad tenants from apartments is detrimental to both housing providers and tenants and the community at large. Think about how long 30 days feels when you have someone that is actively creating safety issues inside of a building, threatening other tenants, dealing drugs, things of that nature. Think about how long the court process stretches out when you can't even file until 30 days after the rent becomes late. This is not an acceptable term, and this needs to be pushed back against at every level, local, state, and national. Eviction case filing should be immediately sealed, including cases of non-payment of rent, thereby reducing the chance for people to be locked out of future housing opportunities without a chance to defend themselves. Again, sealing eviction records is a poor policy decision in my opinion. Someone who's been evicted once is much more likely to wind up going through the court system and being evicted a second time, and limiting the access to a landlord to have access to that data basically puts you in a situation where you are no longer in control of your tenant selection criteria. When other people are deciding what data you can and cannot look at, you are no longer in charge of how you select your tenants, and that's wrong. You are the one who's responsible for the property. You are the one who's taking the risk of property ownership and leasing a property out to a tenant. You should be able to make determinations on who you're placing in your units using as much data as available. For those renters carrying rental debt, fair debt collection practices should include the ability to enforce payment of rental debt only if there's a clear, unambiguous evidence that the debt is owed. It's called a tenant ledger. And freedom from unfair, deceptive, or abusive attempts to collect. I assume that this is probably going to fall somewhere in line with the FDCPA, the Fair Debt FDCPA, Fair Debt Collection Protection Act, which is typically what you find in collection agencies and things of that nature. I don't necessarily think that this is a bad thing. I don't think that we need to badger our tenants and harass our tenants when it comes to rent collection, because we have the ability to take tenants to court. That said, none of us want to wait 30 days when the rent is late to start that eviction proceeding. Moving on, such findings indicate that not only does excessive debt accumulate during the eviction process due to late fees, but that the accumulated debt is then sometimes maintained and leveraged by housing providers who use it to threaten a tenant with eviction. Yes, you have to pay your rent, and if you don't pay your rent, the bills are going to continue to accrue. I don't know where they're even coming up with that one, to be honest with you. The reality of the situation is if you, as the landlord, stop paying your mortgage, you're going to have late fees. And if you don't pay your March mortgage, when April rolls around, guess what? You owe March plus March late fee plus April plus probably an April late fee. Fees accrue and charges accrue when you stop paying your bills. Doesn't matter if you're a landlord or a tenant or anyone else. You have to make sure that you're following. You have to make sure you're paying your bills. It's as simple as that. I don't know how much clearer I can make that one. Tenants know that the impact of an eviction extends well beyond the eviction itself. For example, eviction records are often included in background checks, even when a case is dismissed on the merits or dismissed because the tenant pays overdue rent. An eviction filing often continues to appear on tenant screening report and impedes a renter's future ability to find housing. Although many states have passed laws to seal eviction records, New York State being one of them, when eviction records are not sealed immediately, they can still haunt families. This is because background check companies may fail to remove records from their databases after they are sealed. This goes back to one of the previous sections, what we were talking about. Data needs to be accurate. These credit reporting companies, RentPrep being one of them, should be producing accurate data, not just whatever data falls out of the database. Database data is automated in a lot of instances, and you do need to verify that data to ensure it's accurate. But the more you reduce our ability to look at data and verify that things are accurate, the worse the tenant selection criteria are going to get. Scrolling down a little bit here, FHFA requires that tenants of multifamily properties with mortgages backed by Fannie Mae or Freddie Mac who are subject to eviction for non-payment of rent must be given 30 days notice to vacate before the tenant can be required to leave the unit. This requirement applies to all enterprise-backed multifamily properties, regardless of whether the loan is in forbearance. Enterprise-backed multifamily would be anything under a Fannie Mae or Freddie Mac, I believe. So essentially, this was just something I wanted to point out as a, hey, just so you know, this is something that's already out there. If you have a property that is backed by an FHA a Freddie or a Fannie mortgage, you are probably in a situation where you need to issue out these 30-day notices. Freddie Mac is conducting research on marketable baseline tenant protections and plans to publish a paper as part of FHFA's Equitable Housing Finance Plan initiative. The forthcoming paper will be a survey of each state's landlord-tenant acts across a series of topics that span the rental experience, including tenant screening, habitability, and notice requirements. It will also provide a consolidated source of information on current state landlord-tenant laws, which differ from state to state, for the public and industry stakeholders. MAC intends to utilize its research to develop potential incentives for enhanced tenant protections in 2024. This is overwhelmingly the only good point in the entire document, and it comes in the very, very last paragraph. And essentially what it's saying is, if you want to have national housing laws, you need to figure out where you're at now before you start adding more legislation on top of the legislation that we already have. Frankly, out of this entire 19-page document that we've reviewed here today, this final paragraph is the only paragraph that makes sense, and all it says is we need to understand where we're at before we figure out where we're going. Oftentimes, legislation gets considered and written and passed by people that don't have a stake in the game. They aren't landlords themselves, they're not housing providers themselves, but they're legislating industries that they don't understand. And this is not exclusive to the housing industry. This happens in pretty much every industry universally across the country, and it has to stop. If we're going to start legislating everything, we need to have people writing legislation that are actually competent in the fields that they're legislating. So there you have it. The White House wants to push even more legislation down on us on top of what we already have. What are your thoughts on this? Do we need to overhaul landlord-tenant law at a national level, or should this be something that keeps being maintained at the state level? Drop us a comment down below and let us know what you think. I'm Andrew Schultz for RentPrep.com, and we'll talk to you soon.